I'm so happy to be here with you all this morning. I realized as I've been practicing this presentation that I was maybe a little ambitious, and so some of the stuff I might skip over some slides so we can save time for the meatier parts of this presentation. I've titled this What the Bench Should Know, which maybe feels also a little ambitious. There's a lot that everyone working in the system should know about attorneys representing children. Today's presentation is really going to focus on sort of the right to counsel for children in dependency and termination proceedings, attorney practice standards, and then I'm really going to get into what's known as the legal interest representation model for children. This is a unique model of representation that's really standalone in the state of Washington, as far as we know, for the model of representation that's reserved for representing children who are too young or otherwise, incapacitated and unable to direct litigation. At the end of this presentation, I have some hypos, which I'm really hoping we have time for, because it's they're good. They'll be fun to work through. So first, I'm going to give just a brief introduction to the Children's Representation Program for folks who might not be familiar. We are a program that's housed in the Washington State Office of Civil Legal Aid, or OCLA. OCLA administers the Children's Representation Program. We are a creature of statute, and we are charged with contracting with attorneys across the state to provide legal representation to children and youth appointed counsel pursuant to RCW 1334-2121 and 3. And we'll get into that a little later into the presentation and go over what those sites actually say. The CRP team, there's 9 of us. We are small but mighty. We have myself, a program director, 3 managing attorneys, a training and operations manager, our client voice and community impact coordinator, and then 3 members of our administrative support staff. So if you are interacting with the CRP at any time, these are the fine folks that you'd be engaging with. Our managing attorneys are the ones who you as judicial officers might actually see more frequently in this program. They often attend hearings or observing court proceedings because their role is to monitor and oversee the performance of attorneys on contract with the office to represent children and youth in these dependency proceedings. So getting into the actual right to counsel, I'd like to talk a little bit about how we got to where we are today. Because for most of the history of child welfare in Washington state, children have not had the right to legal representation in dependency or termination proceedings. These determinations were made on a county-by-county basis. Some counties afforded counsel to youth, others didn't. And even then, there was no real kind of unifying practice standards that attorneys would have to abide by. So what might be an acceptable caseload standard in one county that assigns counsel to youth might be grossly inappropriate for another county. And so there just really wasn't any uniformity in the practice. So when we really start seeing sort of the modern evolution of the right to counsel, June 2010 is sort of the first date I've landed on. And this is when a law was passed that required that children 12 and older be informed of the right to ask for an attorney. So there's no entitlement, no right to counsel, but we start to see kind of the legal consciousness open up and understand that, there might be something to at least advising children that they have the right to ask to have an attorney appointed to their case. In 2011, we see the right to counsel enacted for youth in the extended foster care program. So that technically is kind of our first modern statewide right to counsel, but it's not for minors, of course. It's for young adults who are participating in the extended foster care program. That changed in July of 2014. We had a historic legislation that granted the right to counsel for children who remain in dependencies 6 months after the termination of both of their parents' legal rights, meaning they're legally free, they're legal orphans. And it was a bright line rule that at that 6-month mark, if a child remains in a dependency, then they have to have an attorney appointed to them. And this is where we see the birth of the Children's Representation Program. We did not exist before this law was enacted, and OCLA was tasked with administering this law, meaning we contract with attorneys to represent those children who now have this small subset of children who now have this right to counsel in dependency proceedings. Several years later, the legislator directed a study to evaluate dependent children's legal representation. They wanted to see what sort of effects legal representation might have on the outcomes of a case for children. So this study was conducted between 2017 and 2019, and it provided legal counsel for all children in dependencies, regardless of age, and at all stages of proceedings. So essentially universal representation for children and youth in dependency proceedings. The subject counties were Grant and Lewis County, the control counties were Douglas and Whatcom, and the Office of Civil Legal Aid's Children's Representation Program was the administrator of this study, meaning that we were responsible with recruiting the attorneys, training the attorneys, overseeing their performance, and otherwise providing technical support and assistance throughout the study. The Washington State Center for Court Research and the University of Washington were the researchers involved in the study, and they wrote a report after the study concluded in 2019, kind of highlighting some of the impacts that this legal representation, this universal legal representation had. They reported that there were 45% higher rates of reunification for children in the study counties versus the control counties. We saw a 30% decrease in placement disruptions and a 65% reduction in non-normative school changes, meaning children were able to maintain their schools even if their placement's disrupted and they had to move out of district. So increased educational stability, increased placement stability, and higher rates of reunification for those children that were afforded counsel. Because of this study and the great results we saw from OCLA contracted counsel, the legislature in 2021 enacted Second Substitute House Bill 1219. You will often hear me refer to it as House Bill 1219 or just 1219 because it was huge, for the program and for children in Washington State, more importantly. And this is the law that expanded a child's right to counsel. So we moved away from just those children who were 6 months legally free without a resolution due to dependency into the current state of the law, which is that children who are 8 and older in a dependency are entitled to court-appointed counsel, and that for those children under the age of 8, they become eligible for mandatory appointment of counsel if and when a petition to terminate parental rights is filed. It has to be a petition to terminate parental rights. If it's a guardianship, it doesn't count. If there's never anything filed for that child under the age of 8 other than the dependency, they won't have counsel. But that, like I said, for those children who are 8 and older, it's an automatic appointment at or before the commencement of the shelter care hearing. And of course, for children who turn 8 during the course of their dependency, they're afforded counsel at that time. This law, although it went into effect in July of 2021, has a gradual implementation schedule, meaning that the CRP, OCLA's CRP, is required to phase in the program on a county-by-county basis over the next several years. Originally, the kind of deadline was 2028. This legislative session, that there was a law that was just signed, in fact, a couple of days ago, that delayed our implementation schedule to 2030. So we are on pause until 2030, and we will not be fully statewide until 2032. And I'll talk about that a little bit more later in the presentation. So the right to counsel law, the appointment of counsel rather for children, is codified in 1334-212. And what I've done here on this slide is I have sections 1, 2, 3 from the statute with just my little recap of what they are. So subsection 1 concerns the mandatory appointment for legally free children. Subsection 2 concerns discretionary appointment of counsel at county expense, pursuant to a Matthews v. Eldridge analysis. Matthews v. Eldridge isn't the language that's used in the statute, that comes from case law, but that is the part of the statute that allows judges to appoint counsel just because they see that it might be necessary to protect the rights of a youth and that the child doesn't otherwise have the right to counsel. If that does happen, the only kind of significance about subsection 2 there is that if there is a discretionary appointment, OCLA is not involved. We do not pay for that counsel. It is done at county expense. We're not overseeing those attorneys. We're not holding them accountable to any sort of practice standards. That's all still managed at the county level. And then finally, subsection 3 is that expanded right to counsel, that 1219 right to counsel law, where we have mandatory appointment for all children 8 and older, and then all children regardless of age upon the filing of a termination petition. These are the slides I'm going to kind of move past. I thought I might highlight some things, but it's going to eat up more time than I think I can afford this morning. So what is OCLA's role in administering RCW 1334 212 subsections 1 and 3? As I've referenced, we recruit, train, compensate, and otherwise maintain a statewide panel of attorneys to accept cases under these subsections of the statute. We are not a public. We do not provide representation. The statute specifically and expressly forbids us from doing any sort of direct representation. And so that means we're not actually really involved in the actual appointment of counsel either. So for folks who, again, maybe are not as familiar with OCLA, a lot of judges are accustomed to, when appointing counsel, assigning a local public defender's office, and that's just who they list in the order appointing. It gets sent to the PD, and they make an assignment. OCLA is not assigned to these cases. We're not appointed. In fact, it's our panel of attorneys that are appointed to these cases. We have, I'm happy to say, expanded that 1219 Right to Counsel program into 20 counties as of January 2025. I have that listed here for folks. I won't read off all the counties. But then for the counties where we haven't fully implemented that expanded right to counsel, we still operate our legally free representation program. So that's an important thing to note, is that our office is a presence in all 39 counties in Washington state. It's just at what capacity. It looks a little different right now and will continue to look different until 2032 at this point. Let's touch a little bit on the impacts of the statewide right to counsel. So, of course, prior to the Children's Representation Program and these statewide right to counsel laws, there was no broad-based requirement that attorneys practice in accordance with any sort of practice standards. There was no formal mechanism for enforcing or overseeing their compliance with practice standards. And it really created disparities in outcomes and sort of the quality of representation that children might be receiving across the state. With the passage of that legally free statute and the expanded right to counsel laws, we see this phenomenon that we like to call standards-based legal representation. And that is because these statutes require that attorneys practice according to a written, published set of practice, caseload, and training standards that we will get into later in the presentation here. And these standards have training requirements, caseload limits, and just general practice expectations that every attorney on contract with OCLA must abide by. Excuse me. It also establishes oversight and enforcement mechanisms that, again, were lacking before. Because we are a statewide presence, because attorneys who are appointed pursuant to these statutory subsections have to be on contract with OCLA, we have the ability to enforce and ensure that attorneys are practicing according to these standards. So what are the practice standards? They're a big deal. So our existing ones, our current ones, were actually revised in 2022. Some original ones were established in 2011. I can get into that a little more later. But that House Bill 1219 that I've talked about, that expands the right to counsel for children in foster care, actually also called for the Supreme Court Commission on Children in Foster Care to convene a children's representation work group to update the then existing standards at the time. They've been published in 2011. It had been 10 years. Surely there had been developments in the practice that needed to be reviewed. And so the commission, the CCFC, convened a group of people for this work group, and it included alumni of care, so young people with lived experience were part of this group. We had a parent with lived experience, judicial officers, social workers, mental health experts, that legal expert in ethics, and I think not most importantly, but I think notably, the work group itself was chaired by both an alumni of CARE and the then Sierra Children's Representation Program Manager, Jill Mallett. And this composition of the work group looks much different than the original work group's composition, which lacked any sort of involvement from lived experts. The Commission on Children in Foster Care ultimately adopted and published the work group's updated standards in September 2022. And so these have been operative for almost 3 years now as the practice, caseload, and training standards for attorneys doing this work. So I'm going to go over some of the standards, so the kind of the highlights. Those old caseload standards from the 2011 original standards maxed out an attorney's caseload at 60 clients and 80 total cases. The existing standards today actually reduce that maximum caseload down to 45 clients and 60 total cases. This is considered full-time work, and full-time work means you're not doing anything outside of this job. So if you have a full-time contract with OCLA representing up to 45 children and 60, total cases, you're not having an OPD contract to represent parents and a small felony practice and maybe a private family law practice. Our expectation and indeed the expectation of the standards is that this is your full-time work. You're not taking on anything else. The standards also establish pretty stringent training guidelines, even more so than the 2011 standards. There was an increase in training requirements. We have a what we call a foundational training series for our attorneys. It includes, well, I have on this slide, I say 40 plus hours. It's probably closer to 50 at this point. But it's a virtual training academy that OCLA has created and hosts for attorneys who are new to the practice or maybe just need a little bit of a refresher. The program does have discretion to waive some or all of these foundational training series requirements if an attorney can demonstrate sufficient competency in relevant subjects. So a good example of that is an attorney who's been representing parents for the past decade. They probably understand 1334 pretty darn well. They're not going to need to sit through that module of our training academy. However, they're probably going to need to sit through trainings we have on, culturally competent representation, trauma-informed communication with children, collateral issues, kind of unique to children. So it's all to say that even a very experienced attorney could be required and would be required to do at least some of this foundational training series. There's also ongoing training requirements as part of the standards and therefore part of OCLA's contract with these attorneys. Attorneys have to have at least 8 hours of child welfare related trainings per year, with topics rotating according to Appendix A of the standards. And that appendix just lists out every competency area one might want to see an attorney doing this work have competency in. And so that's something we just continuously rotate over the years to ensure that we're hitting all of the topics that attorneys need to render standards-based representation for youth. We also require our attorneys to certify compliance on an annual basis. So that, again, part of that oversight mechanism that OCLA has includes certifications such as these. As far as practice guidelines are concerned, I wanted to highlight 3 different areas that the standards go into. Number 1 is the models of representation that attorneys are expected to render when representing children. Now, the standards presume, just like the rules of professional conduct, that client representation is client-directed, or stated interest representation is a term we often use. But for children who are unable to direct representation, we have what's known as the legal interest representation model. And that is something we're going to go deep into later into the presentation here. So I won't touch much on it here, but just understand that the standards introduce for attorneys that these are the 2 models of representation available to them to ethically, effectively, adequately represent children in these proceedings. There's also discussions on client contact and communication. Attorneys are to have trauma-informed, developmentally appropriate communication with these children while they are lawyers and these are their clients. We don't get to just pretend that they're like mini little adults that can understand all of our legalese. So the standards do expect attorneys to be modifying their practice and their communication to meet the needs of their clients, which really all attorneys should be doing, regardless of the age of their client. The standards also require these attorneys to be having monthly contact with their children and youth, regardless of age or ability. That can be by phone, Zoom, in-person communication, texting, for the teens. But some sort of monthly contact with their youth, visiting them at daycare, things like that. And then they're also required to have regular in-person contact. We know that children need to have in-person communication with the adults in their life and especially with their lawyers to develop the kind of trusting relationship that's required to have an effective attorney-client relationship. So I will tell you, we are regularly sending our attorneys all over the state and all over the United States to actually go and see their child clients in person. That's a requirement that we take very seriously at the program, and again, is something that we are monitoring as part of our oversight and support function. And finally, I'd like to just kind of highlight for folks the level of participation that's required of attorneys in these cases. It might feel obvious to the folks on this call, but we have found that there's sometimes this, I don't know, thought or expectation that attorneys are just sort of there to almost be window dressing. And the reality is that these are lawyers and they are representing clients. And so they are expected to show up as lawyers. They should be at hearings and, permanency planning staffings, FTDMs, other shared planning meetings where the substantive rights of the child are at issue. They are to be reviewing discovery, filing motions and briefs, doing legal research, doing out-of-court, negotiations with other parties. They're fully showing up and participating in these cases as we would expect any attorney to be doing, and that's laid very clearly out in the practice guidelines for the standards. Right. And I think I'm probably like moving too fast. We're going to get really into the meat of this presentation, which is the legal interest representation model. I want to give a little overview first. So what this model of representation is client representation that's rendered by identifying, protecting, promoting, and enforcing the legal rights of dependent children as embodied in statute, case law, court rule, DCAF policy, or really any other authority that bestows a legal right to a child who is a ward of the state. And this model of representation is reserved for children or youth who cannot meaningfully direct representation, such as pre-verbal or nonverbal children. Where does this model come from? Well, we first see it on a national scale all the way back in 1996, and where the American Bar Association published guidelines for attorneys representing children in dependency proceedings. And they don't really go deeply into what legal interest representation is, but they acknowledge that attorneys representing a child's legal interests in circumstances where a child is unable to express a position. So that's where we kind of first see it enter the national legal consciousness, at least. Then 2010 comes rolling around, and we see the Commission on Children in Foster Care being asked again to convene a work group to develop voluntary training and caseload standards. Those are those 2011 standards, what ends up becoming the 2011 standards that I referenced earlier in the presentation. And so that work group gets together, comes up with our first set of practice training and caseload standards published in 2011. And in those standards, they actually adopt legal interest representation model as the model of representation attorneys are to use when representing very young children. So this has been around in Washington State since 2011. I think it's becoming better understood and known as the program is now expanding since 2021. But really, it's not super duper new is where I'm going with this. It has been around for a while, albeit in voluntary practice standards form. First, in 2021, we have that expansion of the right to counsel for children in foster care, and a call for updating those 2011 standards. And of course, the standards that ended up being published in 2022 and adopted also adopted the legal interest representation model for very young children or children unable to direct representation. What I note here is that these 2022 standards kind of greatly expand upon the concept and the mechanics of the legal interest representation model. And that's significant because, and I won't read this, but this was what the 2011 standards had to say about legal interest representation. It kind of explains what an attorney should be ultimately kind of trying to do in those situations where a child cannot communicate their legal interest. 2022 standards is a two-parter, actually has a subsection 1 that sort of defines what legal interest representation is here, and I've bolded a line about Bromby State that I had planned on talking a little bit more about, but in the interest of time, I'll kind of blast through. But we have section 1 that sort of defines the legal interest representation and what it is, and then subsection 2, which really kind of goes into the mechanics of how it is actually rendered. So we get a little more direction for attorneys on how to render this model of representation, which is great because OCLA is responsible for training attorneys on this and making sure they're practicing according to these standards. The sentence in subsection 2 that I've bolded here is important because it shows that the drafters of these standards took great pains to make clear that legal interest representation is not best interest representation, and that it is the court's obligation and duty to determine what is in the best interest of the child, not the attorney representing that child. So how did we land on this model? Yeah, the ABA talked about it in 1996, that showed up in 2011. Like, why are we still using it today? What's going on? So back to that House Bill 1219, not only did it expand the right to counsel, call for an update of the standards, it also called for a review of available research into the best practices regarding representation of children under the age of 8. Technically, Washington's been doing this since 2011, but like, is this the best model? Legislators wanted to know. So the UW School of Law partnered with the Children's Representation Work Group and actually conducted a national survey. And they concluded as a result of that survey that the legal interest model is the best model of representation for children who can't direct representation, as it not only comports with an attorney's ethical responsibilities, it also provides for de-biased legal representation, which we know is a goal of the judiciary in this state. The survey also identified 2 major competing representation models as part of that survey. I'll touch on them just kind of briefly. So what we see is across the United States, for states that do appoint counsel for children, for young children, there are 2 different models that most states use. We have best interest and substituted judgment. Best interest, of course, I don't need to belabor, but and from the perspective of an attorney doing best interest advocacy, it would be the attorney determining their legal position on a matter for a child who cannot direct representation based on what the attorney has determined in their own kind of judgment, what they think is best for the child. I'd say most states utilize some form of best interest advocacy for children that do receive counsel who are young enough or otherwise incapacitated to where they cannot direct litigation. Then there's the substituted judgment model. For anyone who's ever done elder law or had to sit on one of those dockets, they might be very familiar with this. It was kind of a newer one for me when I first started. But this is where the attorney, in this context, would determine the legal position of their client by placing themselves in the shoes of their client and effectively kind of guessing what the child would want in a certain situation. Were they able to communicate those wants? Interestingly, the National Association of Counsel for Children, or NACC, actually recommends this model of representation for pre- and nonverbal children, and we do see some states adopting that model of representation. So why does Washington reject best interest when everyone else seems to be doing it? Well, number one, the work group determined that it does not actually comport with Washington State's rules of professional conduct, that it does not constitute protective action and does not promote a normal lawyer-client relationship, and so therefore would be inappropriate. Of course, again, the rules of professional conduct presume client-directed representation, and best interest just fell too far afield of what it would look like in a normal lawyer-client relationship. They also found that best interest representation introduces the potential bias in an already biased system, and that's not just the work group's opinion, that's the Supreme Court's opinion as well. And I've pulled a quotation here from In Re KW, which was decided by the Washington State Supreme Court in February 2022. And they note that there's a danger of improper biases about best interests contaminating the decision-making process, and that actors in child welfare proceedings must be vigilant in preventing bias from interfering in their decision-making. And so as the folks responsible for establishing practice standards for attorneys representing very young children, they determined that having attorneys doing best interest work was just too great of a risk of introducing additional biases into the decision-making process. And finally, they felt it was duplicative. We already have social workers, GALs, CASAs. They're all statutorily directed to promote the best interests of the child. Why do we need an attorney sitting up there doing the same thing? And as for substituted judgment, folks found that it was just fundamentally limited. It doesn't really make sense to have a model that really relies on a compendium of life experience for an attorney to make decisions based off of. Babies and very young children don't have any prior life experiences. They're not making prior statements or courses of conduct that an attorney might be able to extrapolate a position from. And so really what that ends up, or where that ends up getting us, is a situation where attorneys are really just rendering best interest representation, because what else can you do? You don't have much information that you can go off of, and so of course you're going to just decide what you kind of think is best in a given situation. So I'm going to touch on some ethical considerations for legal interest representation. Folks might be wondering, like, where does this fit into the grand scheme of the rules of professional conduct? These are the four RPCs that I like to touch on anytime I'm doing presentations on representing children in dependency proceedings. It applies, of course, to verbal and nonverbal children. We have the scope of representation and allocation of authority, communication, confidentiality, and then we're going to get to clients with diminished capacity. Everyone's familiar with RPC 1.2, but of course I highlight it here because it is the RPC that establishes client-directed communication, or sorry, client-directed representation in Washington state. And of note is the fact that there's no distinction made here between adult clients, minor clients. The RPCs don't care how old your client is. The default model of representation is that client-directed representation. Confidentiality, of course, we all know what that is, but again, I highlight it here because, again, there's no special exception, right, for if your client's, of a certain age or under a certain age, then you don't have to keep client confidences. That's a requirement for any licensed attorney in Washington state, regardless of who their client is. And then finally, 1.4 concerns communication. Well, once again, you won't be surprised to learn the RPCs don't make a distinction for children who might be a lawyer's client. The lawyer, regardless of who they're representing, has this duty to inform and consult and get feedback from when they're representing a client, regardless of how old they are. So that's all well and fine, but what do you do when you represent an infant? You can't tell them about the case. They don't know what's going on. What kind of confidences could they possibly have? And obviously they're not going to be able to direct litigation. Well, that gets us to RPC 1.14. And what I like to do here is just kind of highlight for folks what I find very interesting about this rule is that in Section A, at the beginning of the rule, the drafters felt it was so important to highlight that even where a client's capacity is impacted, the lawyer still has to do what they can to maintain a normal client-lawyer relationship. That's very, very important to this practice, right? So number one, the drafters are like, you might have a client with diminished capacity, but you can't just throw all your other ethical obligations out the window because of that. You still got to try to maintain that dynamic, that default, that 1.2 default client-directed representation dynamic. But, Section B, if your clients can't really, meaningfully direct representation, then you can take reasonably necessary protective action. And of course, the rule talks about some examples of what protective action might look like. So what does this have to do with legal interest representation? I would say everything. Before we get to that, just to really drive home this idea that, and not idea, it's just a reality that the RPCs don't make distinctions between child clients, adult clients. The comment number 1 to 1.14 is actually one of the few, if not only, places in the RPCs that even address children. And they do it to say that even children as young as 5 or 6 years of age are entitled, have opinions that are entitled to weight in legal proceedings concerning their custody. So I bring this up to say, when we're thinking about representing children. There's not like some magical bright line rule that says, well, a 5-year-old is able to, direct representation, but a 4-year-old's not, or an 8-year-old can, but a 7-year-old can't. Children's capacity is going to look different depending on the child, depending on the legal question at issue. And so I find it interesting, and I like to kind of remind folks that even the RPCs that generally don't make any sort of distinctions between children and adults went out of their way to say, gosh, even a 5 or 6-year-old might have some opinions that judges should be listening to in legal proceedings. Now, back to this reasonably necessary protective action. Legal interest representation is a form of protective action. That's what the drafters have determined, and what we argue here. So the reason why that is that, number one, with legal interest representation, of course, the attorney is promoting and protecting and defending the legal rights of a child. And of course, the law presumes that a child's legal rights are what are in their best interest, meaning a lawyer is pretty safe that they're making the right call by promoting the child's legal rights, because we have to assume that the drafters of those laws weren't doing it in a way to harm children, right? We hope that that's not the case. So if you're arguing for their rights, you are effectively arguing for what should be in their best interests. The lawyer's sole focus in legal interest representation is guarding and promoting the child's legal rights. It's not about what the attorney wants. It's not about their own prejudices, biases, wants, needs, or the wants and needs of other parties. They are solely focused on guarding and promoting the child's legal rights. Protective action may include requesting a GAL for maybe a discrete legal issue. That can still happen. It's not like there's anything in the law or in the code of ethics that says a legal interest advocate couldn't identify that as an additional step that needs to be taken, but it wouldn't be a substitute for legal representation in these matters. And I think also very compellingly is this idea that the legal interest representation model, particularly compared to any other model of representation that might exist for children who can't direct litigation, is that it maintains a normal client-lawyer relationship in a way that these other models simply can't. Of course, back to 1.2, that's the rule, right, that establishes our default model of representation in Washington state, that stated interest or client-directed model. And of course, that's where the client tells the lawyer what they want, and the lawyer tells the judge, and the judge is the ultimate decision maker. The attorney is not the gatekeeper. The attorney doesn't get to decide, well, you don't actually want to go home to mom and dad, like I'll go ahead and decide what the judge is going to hear and what they might rule on. The client directs that, and then the judge makes the decision. Under the legal interest representation model, we have a situation where the law is informing the attorney's position, the attorney advocates for that position, and then the judge remains that ultimate decision maker. So again, we don't have the attorney as gatekeeper in the sense that their own biases or desires, prejudices, or those of other parties are impacting the decision-making process. It's the law essentially acting like the voice of the child and directing what position an attorney is going to take. And then this, I throw out there that 1.14 addresses the issues of confidentiality for anyone who is wondering, well, how can a client, give consent to release confidential case information that might be necessary for the course of representation. And the rules lay out that it's impliedly authorized where attorneys are taking protective action. So we are covered there. Okay, so that's all the kind of big, heady philosophical description and explanations of legal interest representation. I'm going to get into the actual mechanics of legal interest advocacy. We'll see how we're doing here. I think I'm actually doing pretty good, because what we're going to do is get you all to be absolute experts in rendering this model of representation, and you'll get an opportunity to flex during our hypos. So I have highlighted 5 principles and presumptions that are important to understand when rendering this model of representation. Number 1, the legally recognized rights of the child are in the child's best interests. We've discussed that. Number 2, if the child has a clearly delineated legal right, the attorney has a duty to advocate for that right. They don't get to pick and choose. That's the position they have to take is based on the child's legal right. If a child has competing legal rights, an attorney must present facts and legal authority on all legal rights at issue, but shall not take a position on which legal right should prevail. So it's not like there's this magical loophole situation that happens where, oh, if you have two competing rights, then the attorney gets to pick. The attorney actually has to step back and just inform the court on all of the legal rights and authorities at issue. And again, maintain the judge as sort of the ultimate arbiter of what is going to be in the child's best interests. Which duty to assess and determine course of action is in the child's, not the lawyer's job. And finally, a child may have capacity to direct representation on one matter but not another. Again, no bright line rules. Attorneys have to be assessing child capacity when rendering representation. I have legal interest representation that you can do in 4 easy steps. So number one, as a lawyer, you're going to identify all the legally recognized rights of the child that are relevant to a particular legal issue or proceeding. And you're going to determine what model of representation is applicable for that legal issue or proceeding based on your client's age and capacity. Next, you'll determine what position you must take based on the issue in question and the attendant rights involved. And then you're going to gather and present to the court all facts and law that are relevant to the legally recognized rights at issue. 4 easy steps. I have some practice tips. Might not be as relevant to the bench, but understand that this is how attorneys who are doing this work are getting trained and coached. So number one, of course, children don't stay young forever. That's the funny thing about kids, they keep growing. And so the attorney has to be constantly assessing their client's capacity to meaningfully direct representation. Everyone here knows that these cases can drag on for years. And so representation might start where it's solely legal interest representation. And as time goes on, that child is going to be potentially gaining the capacity to actually provide some meaningful direction to their attorney on certain legal issues. If an attorney is conducting mixed representation, we ask them to articulate to the court and the parties which model they are utilizing for a particular issue to bring clarity and, frankly, integrity around the representation. Representation of young children can be very fraught, we have found, and these are sensitive cases, sensitive issues, and it's just helpful for all involved to understand where attorneys are acting in a child's legal interest and where they are acting in the capacity of the child's stated interest. Of course, when you're looking at a child's legal rights, you can't just look at 1334. You have to be looking at the WACs, case law, federal law, DCOF policies, procedures, court rules. Those are all areas which bear on a child's right as in their status as a ward of the state. And then reviewing your source material, so these laws, case law, court rules, the attorney has to identify the underlying right being articulated and have that inform their position. They're not arguing the exception to a legal right. And this is critical for this model of representation. I'm going to give an example of what I mean by that. So I pulled here language from the statute concerning visitation. And so we know that visits have to occur in the least restrictive setting and be unsupervised unless the presence of threats or danger to the child requires the constant presence of an adult to ensure the safety of the child. So what's the legal right here? So put another way, children have a right to have unsupervised visitation in the least restrictive setting. That's the underlying right. And there's an exception to that right where the presence of threats or danger requires supervision to maintain child safety. Whose role is it to determine whether there's presence of threats or danger such that supervision might be required to maintain child safety? It's not the attorney's job. That's the court's role, right? It's the court's duty to assess what's in the best interest of the child. If there are safety threats, what needs to be done. And the attorney's job is to identify and promote the child's underlying, that underlying legal right. The attorney doesn't get to say, well, I think these parents are a mess, and frankly, there should be no visits at all. And so I'm going to go ahead and argue an extremely restrictive visitation schedule or suspension of visits. That's not a legal interest representation attorney's job. That's the court's job to determine. Of course, I already know you're asking yourself, but what if there are legitimate safety concerns? What an attorney surely isn't going to just ignore legitimate safety concerns for this vulnerable child. And you are correct. We are not. I come back to Brahm. Children have a right to be free from unreasonable risk of harm while in state care. We know that. The practice standards themselves, when talking about the legal interest representation model, highlight that for attorneys, that that's something they need to be keeping in mind. And so how we like to conceptualize it for folks is that safety is always the lens in which attorneys are doing their advocacy. So we say to people, well, how would you advocate on this issue in court for a client who could direct representation? And you got these bad facts. You wouldn't just decide, well, you know what, I'm going to ignore your position. I'm going to argue for something totally different. You get creative. How do we maintain that client's position and that right, even if we can't get it today or tomorrow? How do we work towards that? Are there services that you could be advocating for? Protection orders? Is there maybe a lengthier transition period? Court-imposed timelines for certain events to be happening? Other safety planning measures that can occur? The advocacy should really be focused on achieving the client's legal rights in a safe manner, but the judge is ultimately the one who has to decide whether the concern can be resolved safely, not the attorney. So again, when we go back to thinking about debiased representation, removing the attorney's own individual, life experiences, biases, prejudices, whatever you want to call them, this is how we get there, by making sure attorneys focus on what the legal right is and are tailoring their advocacy to achieve that legal right in a safe manner. But ultimately, the judge is going to determine if that can be done safely and what that safety is going to ultimately look like. The attorney doesn't get to decide that it's just unsafe, and ergo, they are not going to advocate for the child's legal rights. In this section, I'd like to touch on a little bit about kind of rethinking permanence as it's so often been conceived and historically been conceived in Washington state. At least when I was in practice, permanency was often talked about in terms of temporal permanence, getting the kid out of the system, getting the kid adopted, getting the child, getting the dependency dismissed, right? And so with really In re KW coming down in 2022, I think it's been other things that have occurred in our legal landscape since then. Our understanding about permanence for children is really starting to shift. And I like to invite people to think about permanence as a means of making a child whole again. So of course we know under the statute that the child has a right to family integrity. And when they're removed from their parents, that family unit is fractured. This is why under 1334, we have a hierarchy of placement preferences. Of course, the overriding goal of any dependency is to be reunited with parents if it can be done safely, right? So number one, kids have a right to be placed with their parents. And if they can't be placed with their parents, then we say relatives or fictive kin are the next best thing. That relational permanence is going to be our next goal if they can't be with their parents. As a last resort, we don't have parents, we don't have relatives, fictive kin, well, then we'll place them in licensed foster care as our last option. And then I like to include just in parentheses here, placement or contact with siblings. While placement is not among the hierarchy, as it were, of placement options, the statute does acknowledge that contact with siblings, be it through placement or just visitation, is critical to maintaining child well-being and relational permanence. So I keep saying relational permanence. That's not a new term for anyone anymore, but we're getting that concept from in re Dependency of KW. And for folks who might not be familiar with the facts of that case, this is one where a legally free child had been removed from relative care and placed into a licensed home for adoption. And even though there were relatives that were coming forward, making themselves available, saying they wanted to take placement of this child, DCYF argued that permanence is the highest priority for a legally free child, and that vetting these relatives would be futile or drag this case out too long. And so we're not going to do it. We need to get this child permanency. We got to get him out of the system. So the Supreme Court disagreed, and they noted, I won't read the whole quote here, but they stressed that courts have to give meaningful preference to relative placement options, and that children are entitled to procedural fairness in the evaluation of potential placements. We can't use proxies as race or class to deny placement with relatives. They actually have to be meaningfully vetted, be given meaningful preference, because that is, as the court acknowledged, the sort of statutory preference of placements for children in dependencies. The court in KW also touches on stability. And there the court said that the trial court in that case had erred in concluding that stability refers only to future permanence as a stabilizing factor for a dependent child, particularly when a child has existing relationships with relatives, and that permanence is relational, not temporal. And so children have a right to relational permanence. The parties in that case were overemphasizing the importance of future permanence in its decision making, and that essentially the right to a speedy resolution, which is in the statute, does a speedy resolution to one's dependency does not trump or otherwise stand in conflict with a child's right to relational permanence. So takeaways here: a child's right to family and family integrity is broken upon the child's removal from their parents. And of course, the child is best made whole again by being placed with their family if they cannot be reunited with their parent. Case dismissal is not how we define permanence. That is not the appropriate lens with which to be looking at permanence. And that speedy resolution to a case does not supersede the due process right to have meaningful relative placement, or meaningful relative preference. So sorry. And that relational permanence is paramount for children in these dependencies. And that was a real, this case presents a real shift in thinking in this area of the law. And it's important that we continue to keep that in our minds, especially as legal interest advocates, when folks are being tasked with evaluating and assessing all of the different legal rights that might bear on a particular legal question. Getting on time here. So I'm going to do a quick illustration of legal interest representation and how we render it, and then we're going to move into the hypos, and you guys will have an opportunity to work through some of these issues yourself. So I have Kai here, and he's a typically developed, legally free 4-year-old. He's been in and out of home care with paternal relatives who want to establish a guardianship, but DCOF will not file a petition until it completes a home study. You also received notice from the court that Kai's maternal grandmother has petitioned the court for visitation under RCW 1334-385. Maternal grandma has supervised Kai's visits with his parents until their rights were terminated and visits stopped. Kai's maternal aunt has placement of Kai's newborn half-sister, Susie. Maternal aunt is holding herself out as a placement resource for Kai so that the siblings can be together, but she has indicated she is unwilling to be a permanent resource for either child. She is committed to facilitating visits between the siblings should Kai not be placed with her. All right, so I'm Kai's attorney. I'm identifying legal issues here. Number one, we have guardianship. Number two, I know I'm going to have to address visitation with maternal grandma. I have potentially competing relative placements going on, and I have to determine Kai's overall capacity to weigh in on these issues. So here's what my analysis looks like. I know Kai is typically developed as a typically developed 4-year-old, and that he has a previously established relationship with his maternal grandma. This person is not a stranger. He had frequent contact. He has a relationship with this person. And so under these facts, he could probably provide me some pretty meaningful feedback on the prospect of spending time with maternal grandma again. That is a point of reference that this 4-year-old has, and likely a typically developed 4-year-old has, and could provide something meaningful to me about what it means to him to be able to start seeing maternal grandma again. So while the court has to consider a number of factors when considering maternal grandma's petition, it's important to note that Kai does not need to have a sophisticated grasp of every aspect of the petition and for proceedings for his feedback to be given consideration. And this is true under the rules of professional conduct for any, a client of any age or real ability, right? Where our clients don't need to have this sophisticated grasp of legal issues in order to direct and provide feedback on, or direction on how a case should go or what their case goals are. And so under this hypo, I'm likely going to convey to the court what Kai's stated interest is with respect to visiting his maternal grandmother. And I'm going to be sure that I articulate that it's his stated interest so that I'm bringing clarity around the proceedings. Now to the question of guardianship. At only 4 years old, Kai is likely unable to provide meaningful feedback to me on whether he wants a guardianship as opposed to some other legal outcome to be established for him. He's probably not going to be able to articulate to me whether he feels resolution to his dependency should be delayed so that the department can complete a home study per the department's own policy, because again, that's not a requirement of the statute, that's a department policy issue. He's not going to understand what that means. He's not going to really be able to tell me whether he wants to bypass the department altogether and just be the petitioner himself. That's unlikely that a typically developed 4-year-old is going to be able to really direct that. And so when it comes to the guardianship question we have presented, I'm likely to resort to legal interest advocacy in addressing this here. Well, I know that Kai has the right to be placed with relatives, and he already is. He's got a relative placement. He has the right to have sibling visitation, contact, or placement. He has the right to achieve permanency, temporal permanency even. Want to be clear, just because relational permanency is paramount, it's not to say that there's no interest in resolving these cases. Of course there are. And so under these facts, he's with a relative that's willing to facilitate contact with his sibling and who's willing to establish some sort of permanent outcome for Kai. And so with all these facts here, all of his legal rights are being met. Would it be great for him to be placed with his sibling? Sure, but the law doesn't require that. And in fact, that's not a kind of a hierarchy of preference. And so under these facts, Kai, there's really no competing legal interests here. And the attorney, I as his attorney, would be advocating for essentially maintaining status quo. So I am the director of the Children's Representation Program at OCLA. If you can't tell through this presentation, I care very, very strongly about the quality of work that the attorneys we contract with to do this work. And in fact, I am the one that interviews and offers contracts to people. So I really care. And so if you are seeing things in your courtroom that cause you some concern, or just you have questions about, you're like, this attorney is acting, this way, and it doesn't seem to be clear. We're not here to necessarily get people in trouble. We want to coach and support them and have them be successful in this program, to the extent, that they are able to. And if they're not, that's a different analysis, but we're not going to know unless folks reach out to us. So I am a great person to contact. I might refer folks to our managing attorneys, because they are the sort of first line of defense for oversight and kind of compliance issues. But I'm always available. Should you have any concerns, I'm available to talk through things. If you just kind of want to talk through things that you're maybe seeing, but don't be shy, please reach out. Because again, we have a statutory obligation and just our own kind of interest and concerns in making sure this program is top notch and that our lawyers are doing good work. And so we would love to hear from you. And if you have nice things to say, we'd love to hear that too. So don't hesitate.